Welcome to the deep dive. Today, we're really taking a magnifying glass to one of the trickiest parts of negligence law, proximate cause. This is where courts essentially decide, okay, the defendant caused the accident, sure, but is the harm that resulted, too far removed to actually hold them liable? And we're zooming right in on foreseeability.
Exactly. It's really where the rubber meets the road, legally speaking. Think about it. Someone drives carelessly, causes a minor fender bender. Okay, they're definitely responsible for the dented bumper. That's clear. But what if the shock from that minor accident triggers a very rare unknown heart condition in the victim and tragically they die? Is the driver liable for that death? That's the tension, right? The legal system has to draw a line. How specific exactly does the foreseen harm need to be? So our mission today is to really rigorously analyze this doctrine. We'll dissect the difference between needing to foresee the particular injury versus just foreseeing some injury of, let's say, generally injurious nature. And we'll use some key North Carolina Supreme Court cases as our guideposts for this.
Okay, let's unpack that. It's a high-stakes distinction for sure. Before we dive into a specific case, can you set the stage? What's the fundamental legal question courts are grappling with when they talk about foreseeability within this proximate cause idea? What boundary are they trying to set?
Well, the core question is really about defining the scope of liability. Where does the defendant's legal responsibility end? And the black-letter rule for foreseeability, it actually sets a surprisingly low bar. It's crucial for you listening to grasp this. The plaintiff only needs to prove one of two alternative things. Element one, that the defendant might have foreseen that simply some injury would result from what they did or failed to do. Or element two, that consequences of a generally injurious nature might have been expected.
Consequences of a generally injurious nature.
Yeah.
Okay.
And what that means practically is that the law rejects needing the defendant to predict the specific details, the exact way things went wrong or how severe it got. They just needed to recognize their actions created a risk of some kind of general danger.
So, okay, let's use an example. If I leave a banana peel on the floor, classic scenario, I don't need to foresee a specific injury, like, say, a triple compound fracture followed by a nasty infection.
Exactly.
I just have to foresee that someone might slip. Is that it?
That's essentially it. Foresee the slip, the general risk.
Okay. If the bar is that low, why does this seem to cause so much trouble? Why do trial courts struggle with it, and why does it keep getting appealed?
Well, it often comes down to confusing jury instructions, the specific words the judge uses to tell the jury how to apply the law. And, lawyers often push for that stricter view, the one requiring foresight of the specific harm. Why? Because it helps their client avoid liability. And this actually brings us straight to a really important case that helped clarify this, Hart v. Curry.
All right, let's analyze Hart v. Curry. First off, can you lay out the legally dispositive facts? What essential details brought this case to the Supreme Court of North Carolina back in 1953?
Sure. The case centered on a wrongful death claim. The plaintiff was seeking damages for the deaths of his relative. The law calls this person the intestate. And the plaintiff's main argument to the Supreme Court was that the trial judge got the law wrong when instructing the jury. Specifically, he argued the instruction put way too high a burden on him regarding foreseeability.
Okay, so the instruction was the key. And what was the core legal issue the Supreme Court had to decide?
The precise legal question was this. Did a jury instruction that required the plaintiff to prove the death itself, that specific final consequence, was the natural and probable result and ought to have been foreseen, did that instruction correctly apply the foreseeability test for proximate cause? Basically, did it demand too much specificity? Did the defendant really need to foresee the death?
Got it. So what rule of law did the court apply to answer that? Can you state the full black-letter rule they use and maybe break down the elements that directly contradict that problematic jury instruction?
Yes. The North Carolina Supreme Court essentially doubled down on its existing rule. They stated very clearly that the test of foreseeability does not, and that's the key, does not require the negligent person to have foreseen the injury in the precise form it took, nor does it require them to have anticipated the particular consequences that actually happened because of their act or omission. And the court then used this rule to evaluate the jury instruction, emphasizing the correct standard requires foreseeability of only one of two things we mentioned earlier, either element one, some injury, or element two, generally injurious consequences. That's the correct lower bar.
That clarity is helpful. It really draws the line. Okay, now for the court's elemental analysis concerning that flawed instruction. Let's walk through it step by step. The trial judge required foresight of the death. How did the Supreme Court apply the first element of its rule, the part that says you don't need to foresee the injury in its precise form?
Right. So for this first element, the court performed essentially a mini-analysis. The sub-rule is clear. The law rejects needing foresight of the precise form, like death, as opposed to maybe just broken bones or some other injury. Then, the application. The challenged instruction specifically required the jury to find the defendant could foresee the death of the intestate. And the conclusion on this element, death is the ultimate specific consequence. So demanding foresight of death imposed a burden foreseeing the precise form that the established case law explicitly rejects. Therefore, the instruction was fundamentally wrong on this point.
Okay, that makes sense. But wait, if the rule was already established, why would a trial judge make that kind of mistake? Sounds like maybe they were misinterpreting or misapplying an earlier case. Which brings us, I think, to the precedent you mentioned, Drum v. Miller. How did that earlier case clarify this standard about anticipating particular consequences?
Exactly. The Hart court leaned heavily on Drum v. Miller because Drum had already tackled almost the exact same problem with a faulty instruction.
Hmm.
So, performing another mini-analysis focusing on Drum, the sub-rule established in Drum is that the defendant does not need to anticipate the particular injury. Application. The specific instruction that was found erroneous prejudicial error in Drum v. Miller required the jury to find the defendant could foresee the particular injury which was received. See the similarity. Conclusion. Because the very strict instruction in Hart demanding foresight of the death mirrored the kind of specific foresight requirement struck down as prejudicial in Drum, it had to be incorrect as well. The court was basically saying, look, we already decided this. Requiring foresight of the specific result is not the law.
Right. So the analysis really just boiled down to the law requires foresight of a risk of some injury, not the specific injury that happened. Simple as that, almost. And after breaking down why the instruction was far too strict, what was the court's final conclusion in Hart v. Curry?
The court agreed with the plaintiff. It sustained his challenge, ruling the instruction was indeed erroneous and prejudicial to the plaintiff. And, as a result, they reversed the lower court's judgment and ordered a completely new trial. And this decision really cemented the rule. Requiring a plaintiff to prove the defendant foresaw the particular consequences or the precise form of the injury is a fundamental misstatement of proximate cause law. Hart stands as a firm boundary marker. If your negligent act created a risk of general harm, you're generally liable for the specific harm that results, even if it's unusual or surprisingly severe.
That's incredibly rigorous, and it highlights how crucial that distinction between general risk and specific outcome is. Okay, let's make this even more concrete. You mentioned the low bar. Are there any sort of unforgettable or maybe even visceral hypotheticals that really drive home this idea that you don't need to foresee the specific, sometimes shocking outcome?
Oh, absolutely. The classic one, taught in almost every first-year torts class, is the eggshell skull plaintiff rule. Imagine a defendant commits a very minor negligent act. Maybe just a light, careless tap on someone's head. Seems minor. But, unbeknownst to the defendant, the victim has an unusually thin skull, an eggshell skull, and that light tap causes catastrophic brain damage or even death. The defendant is still liable for the full extent of the injury, the death, even though it was totally unforeseeable in its severity.
Wait a second. If the defendant couldn't possibly know about the thin skull, how is that death considered foreseeable at all? That seems counterintuitive.
Because the foreseeability test isn't about the extent of the harm, but the type of harm in a general sense. The law only requires foreseeability of some injury from the tap, like maybe a bruise, some pain, maybe a minor concussion. That general type of harm is foreseeable from a tap on the head. Once that general risk of some physical injury is foreseeable, the defendant is held liable for the actual, specific, and perhaps shocking extent of the injury that occurs. The principle is often stated as, the defendant takes their victim as they find them. Once you breach the duty and create that foreseeable general risk, you're on the hook for all the consequences that follow, even the rare or unexpectedly severe ones. The focus is, was the general class of harm predictable? Not. Was this specific catastrophic result predictable?
Okay, that take your victim as you find them idea really clarifies it. It separates the initial wrongful act, creating some risk, from the perhaps unexpected outcome. So for the listener, maybe someone prepping for an exam or needing to spot this issue quickly in practice, maybe when they see a fact pattern designed to confuse them on this very point, how can we synthesize all this into a kind of step-by-step diagnostic checklist for analyzing proximate cause foreseeability?
Definitely. Having a structured approach is key. When you encounter a negligence problem, especially one where the harm seems disproportionate or weird, follow these 4 steps rigorously. 1. Identify the proximate cause issue. First, ask, does this fact pattern involve an injury where the extent or the specific type of harm seems, well, unforeseeable or wildly out of proportion to the defendant's negligent act? A minor bump leads to a rare disease or a small fire leads to an explosion miles away. That's your trigger.
Okay, look for the surprising consequence. Step 1.
Step 2. Apply the foreseeability rule, the negative test. Immediately, you need to reject any argument or any jury instruction language that demands the defendant should have foreseen the injury in its precise form. So if someone argues, well, they couldn't have foreseen death or they couldn't have predicted this specific infection, you flag that based on Hart and Drum as legally incorrect. That's not the standard.
Got it. Reject the precise form argument. Step 2.
Step 3. Check the threshold, the positive test. What is the standard then? The only required proof is that the defendant should have foreseen that some injury that's element 1 or consequences of a generally injurious nature element 2 would likely result. Did the defendant's conduct, like, say, speeding through a school zone or leaving dangerous chemicals unlocked, create a general risk of some kind of impact or some kind of physical harm, some kind of poisoning? If yes, the threshold is met.
Okay, so did they create a risk of general harm? Step 3.
And finally, step 4, conclusion trigger. If the answer to step 3 is yes, if the defendant's act created that risk of general harm, then they are liable for the actual specific harm that occurs. This holds true even if the extent of that harm was surprising or the particular consequences were not anticipated in detail. Remember, the specific way things played out becomes less relevant once that initial foreseeability of general harm is established.
That 4-step framework is crystal clear. Identify the issue, reject the precise form test, apply the some injury general natures test, and conclude liability if that low bar is met. We've really established that this distinction, general versus specific harm, is absolutely the key to unlocking foreseeability and proximate cause. Once that general risk is foreseeable, the defendant is, as you said, generally on the hook for the details.
Exactly right. And this framework, while it provides legal certainty, it does raise a deeper policy question for you to think about. If the law is willing to hold people liable for the unforeseen extent of harm, like the eggshell skull situation, death from a minor blow, what's the real policy reason for having a foreseeability limit at all within proximate cause? Why draw this line? Why not just say if you caused it, factually, you pay for all of it, no matter how bizarre? Thinking about why the law maintains this foreseeability threshold, even if it's a low one, really deepens your understanding of the whole doctrine.
That's a fascinating question to leave us with. Why have the foreseeability check at all if we accept liability for surprising outcomes? Thank you for walking us through the specific, structured analysis the court used and for providing that clear framework. Use this analytical structure, this element-by-element dissection, when you tackle your next set of source material.